Hello everyone, this is Hua Fangling again. In this short video, we are going to talk about the legal and ethical issues regarding managing talents for public and nonprofit sector. So the legal issues are really stem from the separation of powers. So you have a unique system in the United States. You have the Congress serve as the legislative branch, you have the president and the administrative branch, and then you have the Supreme Court serve as the judicial branch. So then the separation of powers also responding to managerial, political, and legal approaches. We are going to talk about this later. But this does raise a very important question, as we already discussed, because managing public talents is a bit different from the private sector, because public servants are bounded by the laws, right? So they have more legal requirements than the private sector workers. So David Rosenbloom labeled this as constitutional public administration, then really talked about its origins and values and how they organize the government structures and how individuals view this. So let's go back to the separation of powers, talking about like how executive branch really represents the managerial and will focus more on efficiency, like get things done, right? And the Congress, well, on the other hand, they really focus on representing different interests, values, right? So this is the political side. So one of the most important thing for the public agencies is they need to care about social equity. It's one of the fundamental values that should be held by the public agencies in order to secure democratic governance. And also represented by the Supreme Court, and you have the whole legal system and a set of administrative laws to regulate the talent management in the public sector. So what are this so-called constitutional public administration came from, and what's the implication for talent management for the public sector, and why should we care, right? So according to David Rosenbloom, the constitutional public administration from three different sources. One is the administrative laws, right? So then it implies that an administrative agency is a governmental authority other than a court or other than a legislative body. So that really the foundation definition for separation of powers, right? So, but the administrative agency affects the rights of private parties through either adjudication, rulemaking, investigating, prosecuting, negotiating, settling, or even informally acting. So basically means the law really taps into the administrative branch as well. Sometimes people would say that actually the judge actually administers something, right? Because through the court's ruling and many other things listed here. So what about the judicialization? It brings not only law but legal procedure as well to bear upon administrative decision making. So when you are making administrative decisions, including hiring people, firing people, how you evaluate public talents, etc., right? So these agencies begin to function like courts, and consequently, legal values come to play a greater role in their activities. Now, especially like background checking, etc., right? So that might also apply to some of the private sector, but it definitely not as stricter as the public sector. And then, of course, you have to protect not only the individual's constitutional right, right? But also to ensure in defense of their constitutional rights, you have the due process. So that puts more burden on the administrators, especially when they work for the public sector, as compared to when as a private business manager. So the constitutional public administration's implication for talent management is you need to pay attention to these three aspects, but this is not an exhaustive list, right? So first you need to pay attention to adverse actions, and then equal employment opportunity, as well as labor relations. So the constitutional public administration, or the legal aspects of public administrators, it really militates against the efficiency economy, managerial effectiveness, representativeness, responsiveness, as well as political accountability, right? And it is intended to afford maximum protection for the rights of private parties against illegal, unconstitutional, or invidious administrative action. All right, so this is all about the legal aspect. So then for individuals working in the public sector, then we really need to pay attention to procedural due process and substantive individual rights, as well as social equity. Okay. All right, so now let me talk another big aspect we are going to touch is the ethical consideration in public administration. So then some big questions we need to ask and potentially provide an answer in public administration ethics. So why ethics are important, right? So the paper written by Terry Cooper really raised 5 aspects he reminded us that we needed to pay attention. So first is regime values, or the constitutional theory. So this is related back to the legal aspect of public administration we just discussed. And then he also reminded us that we needed to focus on the citizenship theory, as well as social equity, virtual or character-based ethics, and pay attention to public interest. All right, so how can public organizations be designed to support ethical conduct? Because traditionally you have the hierarchical organizational structure, right? So you follow the command, the train, and to implement the action. But in the reality, at each level, and especially for those frontline public servant dealing with citizen clients, they actually have the discretion or autonomy based on the specific situation when they interact with each other. So how can we incorporate some of the benefits of those like discretion or autonomy to be part of the organizational design, so that we can better support not only the frontline workers but also serve the clients better? So that meaning you need to create an organizational culture somehow support this behavior, as long as they follow the legal aspects, they focus on citizen rights, they pay attention to social equity, and they are based on virtue, and they serve the public, right? So this is more like how to design the organization so that to serve the public better. All right, so how to treat people equally and fairly? Because then the only like big conflict between the diverse needs from different people and also the public agency, right? Normally need to treat everyone the same. So if you treat everyone the same, you can't really serve the diverse needs, right? So it means you need to treat people like based on their unique or different needs. Then it will violate the principle, say, okay, treat everyone the same, right? So it really needs the organization when they are thinking about managing talents, serving the clients, somehow strike a balance between the standardization of the organization protocol, but also the variety, right? Because you are dealing with diverse needs, not only from the employees, but also from the clients. That really encourages everyone working in the public sector to seek some sort of a combination of standardization and variety. Now the debate will continue or the conversation will continue because we really didn't have a clear answer like where to draw the line or what's the optimal combination of standardization and variety will better serve the citizen clients or better create policies that will draw talents to work for the public sector. All right, so that will be all for this short video. See you next time.